I think we're now live. We'll do that again. Welcome to our 6th webinar at Holmquist and Gardiner. We have a pretty awesome lineup today, as is always. Great guest, Kathleen Sirianni, and Sydney Safley is an associate at our firm. We'll get to that in a moment. First, I'm going to go through a quick rundown of our COVID-19 orders and things impacting us on the legal front, just so that update is fresh and front and center with everybody. Of course, as we've done over the last 6 months of these, I'll truncate it a little bit since we're all more or less well aware of what's going on. Top of the list right now is obviously Governor Inslee's order of Sunday, Monday, where we've extended a shutdown. A lot of businesses impacted in a number of ways. It's important to take a close look at that order and see where we're at. Social gatherings, obviously in the home, offices shut down to 25%, restaurants and dining, obviously also impacted and shut down. And so it's important to take a close look at it and how your business is impacted. Evictions, nothing much has changed there. That order was extended up this summer to December 31st, 2020 for residential evictions. There's a lot of different impacts to commercial evictions. Safe to say right now, if you are thinking about evicting anybody residentially or commercially, it's important to check with an attorney about the exact implications for your specific circumstances. There are a number of slight exemptions for residential evictions, but right now it's just gotten to a very painful point for a lot of landlords, and we're certainly there if you need it, but I don't think it's, for today's purposes, worth going too far in depth on those things. It's just, at this point, if you are going to enforce or send out a notice of default of any kind, or you're thinking about doing that, you need to check with an attorney first. It is very evident to us that the local jurisdictions are taking these orders very seriously, and if you're in breach of them, they are going to issue fines, and you're not going to get the enforcement mechanism you're seeking. With that, we're going to move into our presentation for today on boundary line and title issues. We're very fortunate to have our associate, Sydney Safley, who does a lot of this work. We are very frequently engaged in clients that have boundary line disputes, whether that's a simple residential matter with a fence running down the wrong spot, and the new guy next door bought the property and is now claiming it as their own because they've recently got a survey, or commercial issues where this is a development site and it's the first time in a long time anyone's looked at a survey, and now there's some boundary and encroachment issues. So we're going to talk about considerations that you should think about, title issues and practical considerations. And after that, we'll circle back with some Q&A, and I'll come back on and we'll make that happen. So if you have questions during the presentation, do type them into the chat box, and we will be answering those as we go. So please don't hesitate, and we'll make sure we do our best to get to those. So without further ado, our special, let's start with Sydney, but just so we're all aware, our special guest today is Kathleen Sirianni, an attorney out of Seattle U, and currently working for the last few years at Chicago Title. We've done a lot of work with their team on all types of matters, and they've demonstrated themselves to be front and center, available, and meeting all of our firm's core values. So being responsive and having that optimistic realism about them, even if things are not great, maybe there's a way that we can work together to solve it. So without further ado, I'm going to turn this over to Sydney and Kathleen.
Awesome. Well, thank you, Emons, and thank you so much for being with us, Kathleen. I can't wait to hear the title perspectives that you'll be able to share with everybody today. I'll get us started. We each have a presentation for you, so I'm going to go ahead and screen share for you all. And great. Okay. So let us dive right into a discussion on boundary line disputes and the legal considerations that one should make when they think maybe there is a discrepancy on their residential or commercial property. Having some technical difficulties. Let's see if I can get this working. All right. Okay, so boundary line issues, what do these look like? The first step is obviously to identify whether or not you have a boundary line issue. So here I have an aerial photograph for you all to demonstrate what these boundary line issues tend to look like. So we have a northern parcel, this rectangular parcel up here. And then we also have this southeasternly parcel down here. And you can see that there are some lines that cross over here. I'll represent to you that early on, this northern parcel actually was this rectangle. But it was discovered by this southeastern parcel owner that there were some encroachments. There's this garden in this area, as well as a line of trees, a shed or outbuilding that's quite close to the property line. And then you'll also notice these 3 lines right here, which is actually their underground septic system. So they had quite a number of issues and encroachments over onto their northern property, or northern neighbor rather. And so this southeasternly property owner actually had to file for adverse possession over the northern property owner, and they were successful actually in gaining this strip of land. All right, so maybe you've identified a boundary line issue. What's the reason to fix them? Why the fuss about all of this? Well, it really comes down to a future sale. If you've purchased or sold a piece of property, you're probably familiar with the Form 17 seller disclosure statement. It's about 4 pages of questions that the seller answers: yes, no, don't know, or not applicable. When you get down to section 1C, you'll see the question, are there any encroachments, boundary agreements, or boundary disputes? So let's go back to this aerial photograph. Let's say you are the southeasternly property owner and you recognize, hey, I've got this encroachment on the northern parcel owner's property. Why should I fix it? Well, if you go to sell, you're going to have to answer yes to this 1C question, because there are encroachments and potential boundary disputes. And that's going to limit the amount of buyers that you have available to you. Buyers will look at the yes answer to this question and recognize that they're not just buying a piece of property, but they're buying a problem and probably a lawsuit as well. So you're going to want to open up your ability to sell the property in the future and take care of that problem right away. All right, so you have a potential boundary issue. How do you go about fixing it? Well, you could do it by agreement with your neighbor, and there's a multitude of ways to do this. Sometimes you see it through a boundary line agreement, and this is a document that's entered into by private parties that agree to fix or adjust the boundary line in the way that they see fit. And you can really go about this any way that you and the neighbor agree to do. And you draft up a document with an attorney and a surveyor with new legal descriptions, and you record it with the county that's applicable to the properties. The other option is to do a boundary line adjustment. The boundary line adjustment is different from an agreement in the sense that while it's an agreement between the private parties, you're actually involving either the city or the county as well. And the city or county will run it through each of its departments to make sure that it meets all of code requirements, such as zoning, or if there's any sort of protected wetland nearby, any issues like that, the county and city approve of it. The boundary line adjustment is also different from the agreement in the amount of time it takes to get this recorded. A boundary line agreement, because you're only working with a surveyor and the neighbor, it can take only a matter of weeks to actually draft it and record it with the county. But because you're involving a government municipality with the boundary line adjustment, it takes a lot longer for it to actually work through all of those departments. And last time I checked with King County, a boundary line adjustment is taking about 1.5 years to push through all of those departments. Now, one option to get around this timing issue that is more recently being used by attorneys is called a friendly quiet title action. It's actually a lawsuit that the neighbors agree to file. One neighbor will file against the other, claiming quiet title to the strip of land that's being disputed. And they agree that they're going to go to the judge and say, hey, we agree to split it this way. will you please enter a judgment for us, and then we can record it on title. This is a way around the boundary line adjustment because the judgment will actually take precedence over the county determinations that would come under the boundary line adjustment. Another option that can come by agreement is an easement. And an easement is actually where the owner who would otherwise lose the property retains it. And the separate owner who would otherwise gain the property, they can continue using that property. So you tend to see easements in the situations where the owner who would otherwise lose the property needs it, usually to subdivide, or maybe they want to build a new residence or building on that property. So it's in their interest to keep that square footage. So they allow an easement to be recorded on title so they can keep ownership of that strip of land that's otherwise disputed, and the neighbor is actually able to continue using it into the future. And easements can be made for any period of time. You can make it in perpetuity, forever, or it can be until a specific end date, or perhaps until one of the neighbors sells the piece of property. Of course, there are disagreements, and sometimes you can't come to an agreement with your neighbor. And if you can't come to an agreement, this will involve litigation. And the two most common claims that we see here are adverse possession and mutual recognition and acquiescence. I'll get more into the details about adverse possession because that's much more common than mutual recognition and acquiescence. But real quickly, mutual recognition and acquiescence involves the neighbors at some point, it could actually be past neighbors, having recognized a different boundary line than what is truly deeded and recognized by the county. In addition, mutual recognition and acquiescence requires that this agreed to line by the neighbors has to be physically marked on the ground. So there has to be a fence or a retaining wall or perhaps logs stacked against each other, actually marking where this agreed to line is. So let's dive a little bit more into adverse possession. First question, obviously, is do I have a claim? And the question you really want to ask yourself to determine if you have a claim of adverse possession is whether or not you've continuously used this disputed land for 10 years as the true owner. There's 5 elements of adverse possession that someone has to meet for a continuous period of 10 years. The first 2 elements are usually pretty easy to meet. It's the last 3 that people find themselves getting into some sticky situations. Let's go over the first 2. Number 1 is actual possession. This is usually pretty easy to meet. You have to physically and actually be in possession of the property. Obviously, if you're not actually in possession of the property, you're probably not going to be claiming adverse possession in the first place. And number 2 is notorious. In other words, were you openly using the property? Were you not hiding your use of the property in some way or fashion? All right, now some of the more difficult elements to meet sometimes, and the first is exclusive use. You have to have used this disputed area exclusively to the exclusion of the neighbor who would otherwise claim ownership to that property. If you and the neighbor had both mowed this property over the 10-year period, you didn't use it to the exclusion of them and you wouldn't meet this element. The fourth element is hostile possession. And hostile possession means that you were using it without the permission of the neighbor. So if the neighbor did invite you over to come and mow the property, then you wouldn't meet the hostility element. I'll also note under this element that at least in Washington state, you can adversely possess knowingly or unknowingly. If you know that this strip of land is not yours, you can go in and use it for 10 years. And if you meet all 5 elements of adverse possession, even though you knew you were adversely possessing, you can still be successful in your claim. Additionally, there can be an innocent adverse possession of property. And the 5th element is uninterrupted. You have to continuously use that property for 10 years. If you use the property for 8 years and then leave the country for the next 2 years, and you don't have tenants that continue using that strip of land, then you won't meet this 5th element. I'll also note, in terms of uninterrupted 10 continuous years, you can actually tack on to previous owners of the property. So if you bought the property from Mr. Smith used the disputed area for 5 years, and then after you bought, you also used it for 5 years. Together, you and Mr. Smith can meet that uninterrupted 10 years. So really, adverse possession, it's a claim where the court wants to see a very colorful history of how you used this property. They want you to demonstrate how you've gone in and possessed it and used it for 10 years. And this can take so many different forms. It can be literally colorful. We've had one case where we had a master gardener who went in and used a strip of land, knew exactly what they planted every single year for the 10 years, exactly when they would go in, fertilize, cultivate, and actually pick fruit from some of the fruit trees that they planted. But sometimes it's not so colorful, or it doesn't seem colorful. It's just everyday uses of the strip of land. It can just be kids that are playing in the backyard, hide and seek, Easter egg hunts. Perhaps you have a fence around your property and you know that the dogs have used that area because they just tend to use the entire backyard. But any sort of recreational stories that you have are always great when you're trying to demonstrate adverse possession to a court. Obviously, this is different if you are concerned with a commercial property. Commercial property, sometimes we've seen that the parking lot is used solely by one commercial building owner. In another case, there was a driveway that was actually only used by one commercial building owner for their trucks to come to the loading dock. And here you're really concerned with that exclusivity element. If your neighbor has not gone onto your property or this disputed area for 10 years, then you'll have a successful claim. But if they've continued using that area, then it will probably kill your claim for adverse possession. Another great example is potential buildings that might have encroachments. You could have overhangs or your actual physical foundation could be on or over the property line. Sometimes sheds or outbuildings are on or over the property line. And this is also sufficient to meet that use factor for adverse possession. All right, so maybe you have a boundary issue and you think you might have a claim of adverse possession, maybe even mutual recognition and acquiescence. What are the next steps that you should take? Well, the first step we always recommend to clients is to talk with your neighbor. See if you can come to an agreement. It's much easier to live next door to a neighbor if you know that you've come to an agreement with each other rather than in the middle of a lawsuit. So we always ask our clients to try and take that step and see if that's an option. Go to their home or invite them over, sit at the table and try and figure out their goals, what are your goals, and see if you can get something to match up. Ultimately, you're probably going to have to engage a surveyor to actually plot out your property lines and any encroachments that you have. This is usually very helpful, even though it's a requirement, it's very helpful to just see what is encroaching and where on your properties. And usually if you talk to your neighbor beforehand and describe these issues with them, sometimes you can actually go in together on the surveyor costs. Ultimately, whatever you do, you're going to need to hire an attorney. If you do come to an agreement with your neighbor, you hire a surveyor, you agree on where you want to put the line, potentially through a boundary line agreement, for example, you're going to want an attorney to actually draft that up and make sure that all of the T's are crossed and the I's are dotted and then recorded properly with the county. Your attorney will also probably bring in title to make sure that all of the documents are correct as well. But if you don't come to an agreement, or maybe you do, still you would want to have an attorney on your side to let you know what are your rights, what are your neighbor's rights. If this does go down the path of litigation, what does this look like for both of us, and what are some options for resolution here? sometimes attorneys can really give you some creative perspectives and solutions to the problem. And of course, if you start litigation, you're going to want an attorney on your side representing you for any sort of claims here. So that is just a very fast-paced review of boundary line issues, adverse possession, and how to go about recognizing it and potentially resolving it. So I will stick around for some Q&A at the end, but for now, I will turn it over to Kathleen for a title perspective on boundary line issues.
Awesome. Thank you, Sydney. Just going to get my PowerPoint up. All right. Well, thanks. That was a really great background. And I just thought it was such a cool idea for you guys to put this together and talk about it from the title perspective as well. So I'll just start with a quick introduction. So as Emons mentioned, my name is Kathleen. I am commercial counsel at Chicago Title. I work with our national group out of Seattle. So we close commercial transactions all over the country. We have some Fortune 10 clients where we're with huge portfolios in every state. So I'm a great resource in terms of Washington, but also outside of Washington as well. And then when it comes to residential, I have a book of residential that's a local book, so King and Pierce County. Of course, I can always connect you with other residential teams throughout the country, but I just wanted to clarify that my focus is national commercial and then some local residential. So first things first, title insurance. We are your due diligence partner. So a lot of times when you're looking into selling a property, you already have an attorney, and that's great. And in that case, the attorneys often call us and we'll gather research, look into things if there's any concern about a boundary line. But if you haven't hired an attorney yet, you can always call us. We do complimentary research. It's not insured, but it is highly reliable. And we'll be able to look back and see if, if you're looking into buying a property, if there was a survey recorded in the past, anything obvious that would jump out. So we're a great place to start, and you can involve us way before you even have a transaction in place. So, just really think of us as your partner that way. So the first step to resolving a boundary line dispute, as Sydney was talking about, is to identify it. And I just wanted to clarify that we can help do that before a transaction is even in place. So in addition to identifying the issue, it's always really helpful to start having discussions with title early regarding insurability, any requirements to insure around or over a particular issue, and then any potential endorsements that could provide that coverage. So it's really useful when people call us and they say, hey, this is the solution that we've come up with. We wanted to run that by you and see from a title perspective if you guys are going to feel comfortable insuring that. And then we can talk to you about, if there are additional requirements that you hadn't thought of that would allow us to feel comfortable insuring, or just give you the peace of mind that, yes, you've met those underwriting requirements. So it's hard to talk about boundary disputes without getting into different types of coverage from a title insurance perspective. So you have standard coverage and extended coverage in commercial. So for the most part, we see people using extended coverage more. A survey is required for extended coverage, and we'll get into that. And then residential is really different. So with residential, we have our homeowners policy, and it's a different ball game, and we'll get more into that as well. Okay, surveys. So surveys are really important and really useful. What we've noticed is that when you have a survey, we're even able to help you read it. Sometimes reading the survey is really hard. I didn't actually include a bunch of screenshots with surveys because they're so hard to read, and especially on a screen. But we even have good clients that will come in and we'll help them go through a survey. And the kinds of issues that are disclosed are unrecorded easements, encroachments, evidence of adverse possession, like Sydney was talking about, discrepancies in boundary lines. So it's a really useful tool, and we actually require a survey most of the time to issue extended coverage. So we'll talk a little bit about survey coverage. So title insurance, when you get into the technical aspect, can get a little bit confusing. So a good way to summarize it is basically all of our policies include survey coverage, but then in Schedule B, we take it away essentially. So we say, you know, anything, basically we say anything that is found on a survey, we read it in to the title policy, meaning we will take any issues that are found on that survey and accept them from coverage in Schedule B. So let's say your survey shows evidence of adverse possession or evidence of a boundary line dispute. If we haven't had conversations about that before and ways to approach it, what you're going to see is in Schedule B, those are the special exceptions that are related to your specific property. We're going to include an exception from coverage regarding what was found on that survey. So that's where, after you get the survey, it's really useful to discuss either with a lawyer or starting with us, just in terms of if there are any ways to solve the issues that are going to show up as an exception, or if there are any ways that we can insure around it. So one of the ways that we can provide affirmative coverage over a special exception or partial affirmative coverage is through endorsements. So for anyone newer to the title world, endorsements are a way to expand coverage beyond the four corners of the policy. And endorsements are cool because we can really cater them depending on what endorsement we're looking at. We can even write part of it ourselves to really apply to that specific property. So the two endorsements that I just wanted to touch on in relation to boundary line disputes are the Alta 9s and Alta 28, specifically Alta 28.1. And we don't expect you guys to remember numbers or anything like that. If you, when this comes up, just call me. And while I can't tell you what to do and I can't give you legal advice, I can certainly tell you what we see. I can tell you from an underwriting perspective what would satisfy us. And I can certainly talk through the different endorsements with you. So the Alta 9, just to touch on it briefly, is only for lenders. And it ensures as to encroachments, improvements from or onto adjoining land or over an easement area. It includes coverage for encroachments into building setback lines and ensures against damages to improvements encroaching into an easement. Now, 9 is only for lenders. We have just a different set of risks and a different way of doing an underwriting analysis when it comes to a lender versus an owner's policy. So for example, if we're in a residential setting, you know, we may be satisfied about, like, let's say there's a small encroachment, like a fence that's just a little bit onto the property line. We might feel comfortable providing an endorsement and affirmative coverage for that for the lender. But for an owner, we would be concerned about an adverse possession claim and the cost of defending that. So there can be a different analysis there, which is good to note. So 28.1 is for owners and lenders, and it ensures as to encroachments of buildings from or onto adjoining land or over an easement area unless accepted in Schedule B. So this is where the discussions become really important. And even when Schedule B is taking away coverage, oftentimes the enforced removal coverage stays in place. So for example, there's an encroachment, you don't have coverage in terms of you know, saying that encroachment isn't there, but you do have coverage if there's a lawsuit brought and you're forced to remove said plants, or so there can be enforced removal coverage, which is just something to note. Okay, so before we go there, so oftentimes when we are asked to insure over an encroachment, the analysis really comes down to how long the encroachment's been there, the you know, who the other party, and just a variety of important factors that usually lead to us saying no, but sometimes in certain situations with the right fact pattern, we can get there. All right, so one of the great things to know about title insurance that is broad and can give you some peace of mind is that in general, if we miss something as a title company, you're covered. right? So I wanted to, so well, we're your due diligence partner. And if we find issues, we may not cover those issues, but it's good for you to know, and you can work them out with your lawyer. And we can certainly talk to you about the best ways to move forward. Anything that we don't find, if something comes up later and we miss it, then that's on us as a title company, and we'll step in and defend and pay the cost to do so. So I thought it would be kind of fun just to talk about a really simple example of a missed encroachment. So the subject property was a single family waterfront home on Mercer Island. There was a homeowner's policy issued to the current owner back in 2006. Now, this is a good time to note that the homeowner's coverage, which is only in the residential realm, does not require a survey. So like I said, extended coverage with commercial properties requires a survey. Homeowners does not. We send out an inspector, and the inspector looks for any potential encroachments or evidence of adverse possession when they go out to the property. So after we issued to our insured the policy back in 2006, in 2010, the owner sues the neighbor stemming from the neighbor's boat canopy encroaching onto the insured's property. So this is why the fact that it's waterfront is important. So let me just show you. So here's the missed encroachment. So like I said, the surveys are kind of hard to read, which you can see on one side. But if you look at that picture, so you see the white boat canopy next to the littler boat. So it's literally just inches of that canopy that we're talking about. And so then the trial verdict was in favor of the neighbor. And basically we missed it prior to issuing the policy. We did have the inspection ordered. The inspection noted the potential encroachments and recommended a survey, and we didn't move forward with that. It was an error, which has led to this being a great example. So, you know, if there's something that hasn't come up in your due diligence process and didn't come up on title, that's where having title insurance is really helpful for any surprises that could come up. Okay, and with that, we can go back and talk through in more details, but I just want to see if there are any questions at this point.
We do have a number of questions. Thank you both, Sydney and Kathleen. Those are spectacular presentations. Sydney particularly liked the PowerPoint color selection. Purple's the best color ever. And Kathleen, I want everyone to write down, Kathleen said it, "You're covered." That was a quote. You're covered.
Depending on the facts, guys, depending on the facts.
A couple of key practice tips that I just want to throw out there. One, I agree with Sydney. You know, if you're in a transaction or if you have a neighbor that's got an issue, work it out. Do your best to be friendly from the get-go. You don't have to concede every point, but being friendly really makes a big difference in how quickly you get something resolved. Sometimes it's a matter of a bottle of wine with the neighbor. Another one is if you're on the water and you're buying waterfront property anywhere in the state of Washington, particularly Lake Sammamish and Lake Washington, just get a survey. Usually there already have been one done, but the reasons are pretty obvious. First and foremost, the property value dictates it. So the issues that you're going to have, if like what Kathleen put up is there, where you're talking about the dock and the boathouse, those are like extra zeros in terms of your total liability exposure. And the second reason is these are some of the oldest parcels in the land that have been, you know, had legal descriptions made for them, and those meets and bounds and the original legal descriptions were all done using the lowest form of technology. It was just right after the wheel was invented. And so generally speaking, the boundaries have been off as much as like, you know, 10 to 30 feet, and whole properties all the way down the waterfront have been off. Now, a lot of those issues have been resolved, but a lot of them have not. And so it's best just to don't think twice about it. We see a lot of issues on waterfront. When to get a survey, and like whether, you know, obviously extended policies and title policies, we often get to, do I need a survey? And of course, our office is going to always say, if you want to know for sure what your absolute boundary is, not just because of a title insurance issue, but for development purposes or otherwise, the only way to know is to get a survey. Otherwise, you are literally just taking that legal description and that's what's there for you. And there's no other way to really confirm it. If you're a residential buyer, of course, there's a lot of coverage for that in the title policy. not full coverage, but pretty good without a survey. And if you are in a commercial setting, you just don't know, and it's unlikely that there's been a course of transaction history that's going to support you down the road. So you're moving backwards from there. So moving on to our questions, a good one that we see here is, what happens if there are two surveys that have of the same property that have some discrepancies?
Definitely. So I can take that one. So surveying, like appraisals, is a little bit of an art as opposed to a science. There's science as well, but so that does happen occasionally. And let's see, I know I have an example. All right. So we had, so this is a little bit different than your question. So this is, we had a survey, we insured the person, and then basically when they went to sell the property, a different survey was done and it showed a 5-foot encroachment, which is quite large. And so what we do is we take that to underwriting. We will go ahead and do our own due diligence of looking at the legal description, seeing what we can find. And then we actually have the surveyors talk to each other. There are different methods that they use sometimes. And so in speaking with each other, they can line up how they decided like which north they would use. I'm not an expert in surveys, but there are these different decisions that they have to make. So yeah, just keep in mind that it's an art, not a science. And if you do get a survey that really doesn't match up to what you were thinking, or if someone presents you with a survey, like a neighbor or something, it can really be in your best interest to get your own survey. I actually did that in my personal life. I had a boundary line dispute with my neighbor and they had a survey, and then I got a survey and it did confirm the same thing, but it really, it was important to me to really have my own independent survey and make sure that there wasn't potentially any kind of a mistake by the surveyor.
Yeah, I think that having your own survey is also important, because if you're talking about an easement area or a specific boundary, sometimes they cover certain things and they'll put in the driveway or not. And you can point out for just for your satisfaction, here are the things I want to make sure you call out. I've seen surveys where they're just not fully complete on certain things that should be there. Another great question we got here, which Kathleen, this is being recorded, so I don't know if you can disclose this or not, but do you have a general sense of what the resolution was of the Mercer Island waterfront matter?
Yeah, so I mean, we were on the hook as a title company because we missed it. My boss, Joe, who actually was the head of our claim center for a long time before joining our national group in Seattle, is on the phone. Joe, do you want to talk about like the diminution of value or anything? No, he's good. Yeah, so we were on the hook essentially. So we had to step in and defend. And so that's an example of a title claim where you're really glad that you have that insurance and have that coverage.
Yeah, and the next question leads right into that, which is, can you discuss the process of making a claim on a homeowner policy where a neighbor's encroachment comes onto the insured's property?
Sure. So I don't know a ton about the whole process, but what I can tell you is there is an email. You just email your claim into, I think it's claims@fnf.com, but someone can certainly follow up with me if they would like. And then I actually have a whole presentation on the claims life cycle, but we have a really good process for how they're evaluated. You hear back within a certain amount of time. There are different ways that they handle the claims. So sometimes, if an insured is really getting ahead of something, but no issue has come up, no one's being sued. Sometimes we'll do a wait and see and keep our eye on it. So there's lots of different ways that it's handled depending on the facts. But really the first thing you need to do is provide notice to the title company, which your lawyer can help you with, or just simply sending in an email with the description of what you believe is going on.
Yeah, I'd say we typically, and Sydney can ratify this, we've typically sent claims letters into various title insurance companies for our clients, where we just want to be pretty particular in making that claim known and with the supportive documents that we have. And then, we'll address the issue from there, or the title insurance company will just take over and get it done. Just kind of depends on the nature of the claim.
Cool. And then actually I just confirmed, so for anyone, you know, Chicago Title is part of a parent company. I actually used to work for the parent company in litigation, and I chose Chicago Title because it's the best brand. So the parent company is, the claims center is underneath the whole parent company for all the brands. So like Fidelity, Chicago Title, Ticor. So you can send your claim letter into title claims at fnf.com. That simple. Title claims at fnf.com.
Simple enough. Okay, another great question. Our neighbor has been cutting blackberries on our property. Over time, this has pushed it back 10 feet and they now cut the grass there. They are dumping yard waste and other things. My fear is they could prove adverse possession. Is there anything we can do? I'm going to pass this one to Sydney.
Yeah, so the first two elements I would look at here are exclusion and hostility. Have you been using that area in any sort of way? And if you have also been going in there and dumping your lawn clippings, or maybe picking the blackberries, however you've used that area, that could kill their exclusivity element. Element I'd look at is hostility. If you go to them and you say, hey, you don't have permission to be doing this anymore, that completely kills hostility. If they're at 9.5 years, for example, of using that property, and you go over to them and you say, you don't have permission anymore, well, they don't have hostility for 10 consecutive years. So I would definitely take action at the very least and let them know that they don't have your permission to be in that area anymore. And that's a proactive way to go about it. If you have more questions, I'm more than happy to talk through it with you and give you any more clarifications.
I have a question. So
yeah.
I was wondering, okay, so what if you get rid of the hostile element also if you tell your neighbor that it's your property, but you're okay with them using it, right?
Yeah.
So if you say like, yeah, like if you say like, this is my property, but for now, like you could keep cutting blackberries, then that gets rid of hostile too, right?
That's right. Yeah. It sounds like this particular neighbor is being given an inch and taken a mile. So
yeah, so maybe
we need to cut it all off with them. But definitely, if you're okay with them continuing to use that area, maybe they're helping you out actually cutting those blackberry bushes, then at least giving them permission will also kill hostility.
Yeah. And it's a nice way to keep like friendly neighborly relations.
For
right.
Sure.
So you're like putting you on notice. This is my land, but sure, you can walk over there with your garbage can or whatever.
Exactly.
This is where an email confirmation of the permission that you've given your neighbor is a good thing to do. Just, you know, it may not be sufficient. I don't think you should be relying just on that. But if you do say to your neighbor, hey, it's okay to trim this or do that, putting it in writing so it's not, so you can kill that hostility issue is great. The other thing the case law shows is that this gets more into like pathways and trails through a property. There's been a lot of case law suggesting that, and our higher courts in Washington are trying really hard to not let adverse possession run too wild. But cases where you've let someone walk across the property through a pathway, and they've found that, yeah, if you waved at them and said, yeah, that's been deemed permission in some cases. Again, I don't know that you'd want to rely on that. You might want to talk to the neighbor, give them a license in writing, have them sign it as well, indemnify you. It's all sorts of provisions that if you're going to let your neighbor do anything, you definitely want to have something in writing if it's going to be an ongoing thing, so that you've got some indemnity provisions, some insurance provisions. These are the kinds of things that go into when we solve boundary line disputes. We're frequently in an exclusive use easement. We're going to say, fine, you can use that 5-foot strip. You can never build there. You're going to indemnify us from anything that happens there, and you're going to carry reasonable insurance. And we just got the question, is permission equal to a license? I think that technically you can grant a license without a writing, and so it would be maybe classified as a license, but technically speaking, you want to, if it's a true license, you'd want to have a termination date and terms and have it in writing. Permission can be granted without any writing. You could just, like I said, I think courts have found that waiving and not obstructing them from doing that conduct over and over again is enough to kill the open, notorious, and hostile segments of adverse possession. And those requirements were deemed just not met because everyone was aware that permission had been given.
Mm-hmm.
So another great question we got, and I think this will be our last one because we do want to keep this short. We are having a closing coming up within the next 30 days. And we have just learned of an encroachment issue. What can we do to still close on time, if anything? I can tackle this quickly. We have had situations where a deal just had to close for one reason or another. Everyone recognized there was encroachment. The neighbors were communicative and agreed that the property had been adversely possessed, or were willing to sign a boundary line adjustment. I think in the one I'm talking about, the lender was requiring it to be completed. So we did have to do a boundary line adjustment, not just a exclusive easement. And we put a holdback in the deal, and we just held it in escrow, and we waited. It took 6 or 7 months post-closing to get it all finalized. I would not recommend doing that. You never know what's going to happen. But we put extensive damages provisions in, and everything kind of worked out. But there is a way to do it. It's just, you'd rather know about these things as Sydney pointed out. This is going to affect the marketability of your property. You'd rather have this solved on the way in rather than listing the property, getting under contract, and then finding out, oh, there's this boundary line issue. So with that, I want to thank Kathleen and Sydney for joining us today. Their contact information will be in the email that we send out post webinar. We are recording, and so this will be something that would be great to share with your friends and colleagues. And we really appreciate you attending, and we'll look forward to seeing you at our December webinar. These will continue. And until then, have a great time and enjoy the first part of the holidays here. Thank you for coming.
Thank you, everyone.
Thanks, guys.